And good morning to you, sir.
Good morning.
Well, first, let me start by asking you what you make of the manner in which the petitions that have come in, the process have been followed thus far. Those petitions are for the removal of the CJ. The president has initiated the process yesterday, we understand. 10 days given to the Chief Justice expired for her to respond. What do you think so far?
So far, so good. He's complied with the constitutional provision, even though it is not spelled out there that the Chief Justice will have to be given a copy of the petition for her initial comment. I believe that when she asked for it, in fairness, he's giving her a copy, and which copy, I'm sure, by the response that is said to have been sent back to the presidency, I'm sure she must have reacted appropriately.
And you think so far the president has followed the constitution?
Yes, he has followed the due process. As I did indicate, in the constitution, there's no provision of any prima facie issue concerning the case of the Chief Justice. But of course, in the Judicial case, it was made clear that the Chief Justice is first and foremost a justice of the Superior Court. So anything that applies to the justice of the Superior Court, she also have to benefit from same. So if it is a case that a prima facie case will have to be established before a matter is taken against her, in fairness, she should also enjoy same. And so I believe that when she also raised the issue that she should be given a copy, same was complied with. And I believe that it is even helping our justice system.
Well, there are those who have the opinion that the president giving her a petition of a copy at this time is premature, and even asking her for her views when the very understanding of what prima facie means does not require that you speak to the person against whom the petition has been sent. All are premature, that there's no way the CJ should have been involved at this stage.
You see, the concept of prima facie, for instance, when you go to the court, the side of the prosecution will be heard, at the end of which the lawyer may either enter the submission of no case. But there's one thing which happens. In the course of the cross-examination, the lawyer also puts the side of the accused person in issue. So it is like, as the questions go to the prosecution or the witnesses of the prosecution, the questioning should also endeavor to tell the story of the accused person to more or less impeach or to discredit what is being said by witnesses of the state. So when we look at the definition of prima facie, it is taking a look at a document and then on the face of it, what it means or what it is that it can strike you. So I have taken a look at this document and I'm inclined to believe that it may contain some merit which will require some further investigation or some further auditing. For me, whether or not the Chief Justice had been given this particular document is neither here nor there. Because at the end of the day, when there should be the committee set up, she will have to appear before the committee. And copies of this petition will have to be given to her, in fairness, so that she can also appropriately react to the said accusations that have been leveled against her. So as to its premature nature or otherwise, I do not think there is any such thing. If for anything at all, it is rather giving a lot of transparency to what is being done so that it will not be seen as a political witch hunt to just want to get her out of the place. You recall that in the case of Charlotte Osei, she even wrote and asked that she be given a copy. And we all remember what he said. She was never given a copy. And even at the hearing, she was just giving the bullet point. The details were not even furnished her. And at the end of the day, she was removed. So I think that what the president is doing now is better when at the end of the day, the proceedings will come out and for people to know whether a prima facie case was established. If a prima facie case was established and then the committee set up, what was it that the committee found in the course of its investigation? Do those investigations merit the Chief Justice losing a job? And take note, there are 3 basic requirements, any one of which could lead to the Chief Justice losing her job. 1, stated misbehavior. 2, incompetence. And 3, infirmity of mind or body. So for those who are writing against the Chief Justice, if they are unable to establish any of this, then their protestation or their petition can be as thick as the Bible. It will hold water and it will get it and it will be thrown away. But it can be a 1-page document. If that 1-page document establishes that the Chief Justice is incompetent, or she has infirmity of body or mind, or that she is involved in a certain behavior which is unbecoming of her as a Chief Justice, and for which reason she should merit her being removed, that will be carried. So, be given a prior copy or not. Because what she is alleged to have done is in the past. She cannot go and undo it. So I think that it is rather better for our justice system, or in fairness to the Chief Justice, for any such thing to be done. And take note, this whole thing is taking a political twist. But here we are with an MPP, Member of Parliament, pursuing this matter at the Supreme Court. And the lawyer happens to be the former Attorney General. So these are battle lines clearly drawn. And so I think that it will be better for the government not to allow the other party who wants to, as it were, politicize the issue, not to have issue to say, well, we asked for this and it was not given us. And so once we have given it to her, she has also expressed her opinion or her reaction to whatever was said against her. We don't do the contents anyway. So at the end of the day, the prima facie issue must be established. And again, let's not forget that a member of the Council of State happens to be a former Chief Justice. So when it comes to establishing a prima facie case, just as the Chief Justice alone is able to do that, the former Chief Justice who happens to be on the Council of State can equally be asked to also take a look at that particular document and to also pronounce on it, at least as an expert. So I believe what the government is doing, or what the president is doing, is fair. If at the end of the day it happens that the Chief Justice should be removed from office, nobody will be able to read any politics into it, or to say that the whole thing was a setup to just get her out. If you look at the process matter, to date, the MPP is unable to say that this whole thing was not politically motivated.
Now, I wanted to find out what elements will go into making a prima facie determination. Because if you're looking at, you talked about exactly what would lead to her removal: stated misbehavior, infirmity of mind, incompetence. But when you're making a prima facie determination whether or not to proceed, what elements will have to go into that?
Yeah, so in establishing a prima facie case, of course, if it happens to be in a court of law, it should be established that the ingredient which will go to establish the person's guilt has not been established, or that through cross-examination, all that has been said has been so discredited that it can not move beyond the stage of asking the what's the name, the accused person on opening the defense. So we have this person. Somebody is trying to say that a prima facie is established. So you are going to establish a prima facie. On the face of it, in time will have to be established. And it should also be, even when any questions are on the face of what it is that has been written against that particular person, it may not hold much guarantee because those issues stand tall. So as I said earlier on, the ingredients which will lead to the removal of the Chief Justice are these 3 key points that I've made mention of earlier on. So in establishing a prima facie case, it should be established that, okay, from the narration as regards the stated behavior, where she said she has probably done this, she has done that, probably she might have made some payments or made some directives as to the construction of some particular structures, or that she might have used the resources of the judicial service for her personal enjoyment or for her personal aggrandizement, which expenditure are not covered in her official capacity as a chief justice. Those ones will be stated in behavior. I think they are serious enough. Of course, the police being removed. So if there are any such things, then of course somebody is saying that, oh, the chief justice used X amount of dollars to take a trip to say Papua New Guinea. We look at it and it doesn't look like that one falls under expenses that are officially covered by her status as the chief justice. That is what the person is. Having said that, on the face of it, it looks quite true. It looks like the chief justice didn't do what is right. And so the committee will then go into it and see whether or not, in the run-up to being afforded the money or the resources to undertake that trip, certain things were brought to her attention that, hey, this particular thing you can do it the capacity as the chief justice. And she was heedless and went ahead and did it. She could be said to have been impervious to reason or impervious to advice, and which would have led to her committing that particular administrative blunder, and which blunder could result in her being removed. So, yes, when it comes to the just a casual look at the issue that talks to the fore, talking about the stated misbehavior or the incompetence or the infirmity of body or mind. When those things are established, it could be established. For instance, if the person says that, look here, I think this woman has, infirmities of mind, because when she says, she talks, and a lot of the things that she says are not even related to the issue which is before her. So that tells us that this lady has a challenge. Of course, when such a thing is brought up, the lady will be called. She will be subjected to psychiatric examination, whether or not she is corpus mentis or whether or not she is in the right frame of mind. She's in the right frame of mind. It means that particular situation wouldn't go. If it is established that, yes, there is a problem, then of course that obviously will lead to a removal.
I see. How can her rebut? Okay, so she was given the opportunity to put in a preliminary response. How can that preliminary response be critical to determining whether or not? Because maybe if you're looking at the petition without a response from her, you would have determined that a prima facie determination, a prima facie case has been made. But can her rebuttal or a response successfully rebut any allegation and force the President and Council of State to end the issue at this stage?
Her rebuttal will not force them. It's rather convince them. It's rather tell them that, well, there is no substance in the accusation that has been leveled against the lady. So let me just give you an instance. If somebody comes to say that the Chief Justice has spent about, say, 50,000 in the renovation of her private house in, say, Winneba, right? And then the Chief Justice says, oh, yes, it is true. I have used that 50,000 in the renovation of my private residence. But I did it with A, B, C, or D things, and with A approval. Those ones are issues that have been more or less joined, right? The person has said something. You have also said something which is different. So, because these issues are joined, then of course there will be the need for the committee to now get into it and to establish whether or not in the use of that amount of money in improving upon her house in, say, Winneba, whether she followed due process or whether she was reckless in ensuring that the various processes are followed. I hope you understand what I'm saying. But
Yes.
if the person comes to say that, oh, she has used money to do things of her house in Winneba, she comes to say that I don't even have a house in Winneba, right? That is it. Once she said that I don't have a house in Winneba, of course the council of state will ask that, the security people do some investigation as to whether or not she has a house in Winneba. And if they go there and they say that no, our investigation indicates that the lady doesn't have any house in Winneba. Obviously, that particular accusation made against her will definitely, lie flat. I hope you understand what I'm saying. So it is not a matter of her rebuttal forcing, no. But I believe that the Council of State, being made up of very eminent persons and who will not want to compromise their reputation, they will objectively look at the issues as and when they come up and deal with them appropriately.
I see. There's a requirement for in-camera hearings. At what stage does this kick in? Because if you read what the president put out about providing her a copy and then taking her response, you realize the president was not happy that the letter she has written to him for those copies leaked, among others. At what stage do the in-camera parts come in if virtually everything may be out in the public even before this is concluded?
In fact, in the matter of Peter Jerry, the Chief Justice Attorney General, it was just be clear that even the petition in itself, once that one could forms part of all the processes in connection with whatever is going to be done regarding the petition. So when the person makes the petition, that petition is not supposed to be made public. The content of it should not be made public. Everything in the run-up to even a committee being set up, the details of it should not be made public. It is only when the committee has finished with its work, then, of course, the decision which will be taken by the president with the Council of State will then come out, and then you can give us the details of what exactly has happened. Indeed, in the third Dairy case, it was established that even where those things are made public, it will not go to more or less result in the case not being heard. So you realize that in the case of Asepa, in their petition against the Auditor General, they came out openly and told the whole world what it was that they were saying the Auditor General had done wrong, and for which reason they want him to be removed. They were not supposed to do that. But in the Peter Uderi case, it was established that even though that's not supposed to be done, the fact that it has been done will not go to result in that particular matter being thrown away. They will still have to go into it. Unfortunately, there are no sanctions if you decide to make some of these hearings, which are supposed to be in camera public. So it's a tricky area. So yes, the president probably might have been disappointed because probably he wanted everything to be done in some kind of exclusivity or some kind of secrecy, not with any pejorative connotation to the use of the word secrecy. And probably he is disappointed that in granting her that respect and not making open things that concern her, she has rather decided to rather be making things, put in the public domain. That may be his disappointment. But that one is not as egregious, is not so serious a sin or so serious a fault or misdeed as to say that because of what she has done, the president has now decided that, look, because of what you have done, I'm now going to even suspend you. No. If the president is going to suspend, the constitution is clear as to how that one should go on. So yes, the president only expressed his opinion, but he doesn't go to the crux of it. He could have even better kept quiet. He's not even talking about whether or not he was disappointed. But of course, he is entitled to his opinion. If he's disappointed and he wants to express it, so be it.
Well, let me conclude with you on this. And you refer to the case that have been filed in court surrounding this issue and the people involved. Vincent Isefua, who is a member of parliament for the New Patriotic Party, the immediate past attorney general being his lawyer, among others. Does this play to the advantage of the Chief Justice? Or does it not help her case at all?
No, not. The only thing, as I'm saying, that it is giving the perception of a certain political battle line having been drawn. There is no law which forbids an MP from taking a matter to court. There is no law which says that because you have been a former attorney general, you cannot go into a matter which involves the Chief Justice, or you cannot be a lawyer. Because after you have come to the end of your term as the attorney general, you revert to a common lawyer like any other person. But at the time that you are the attorney general, but after you are removed from that position, the group as an ordinary member, of course, you will be granted some regard. People will deal with you differently because you have once been a leader of the bar, and so you may not be treated like just any other person. So generally, there's nothing wrong. Again, when it comes to the empaneling of the judges who are going to hear this matter, the Chief Justice has two roles that she plays. She is first and foremost a judge of the Supreme Court, and so could be a member of a panel to sit on a particular matter. Now, two, she is also responsible for the general administration of the judicial service, and that includes the empaneling of judges for specific cases at the Court of Appeal and then at the Supreme Court. So until she is removed as the Chief Justice, the role that she is expected to play as a Chief Justice cannot be restricted. So one cannot say that because it is a matter that involves her, she cannot, as it were, empanel. Because she was not the one who sent the matter to court. Let's take note that it is an ordinary Ghanaian who happens to be a member of parliament. It is a lawyer who happens to be a former attorney general. These are the persons who have sent the matter to court. And to the extent that she remains as the Chief Justice, she is expected to play her role. Again, we should also give some dividends or some respect to the judges, that these are persons who are independent-minded. And so they are not because they have been appointed by the Chief Justice in respect of a matter who seeks her interest. At the end of the day, they are just going to bend the rules or the law and let it favor the Chief Justice. We all require it. And the law cannot be differently handled because it involves a Chief Justice. If there is a judge who decides that he is going to probably throw away the ethics of the understanding that should be given or the interpretation that should be given to the law, and he decides to just be careless and do things, he will leave of it. For instance, there was a time a certain judge said something in respect of a document. I'm not going to mention it, otherwise people will know the judge I'm making reference to. I mean, that particular judgment the judge made has been seen as outrageous. But unfortunately, since that particular judgment has not been set aside or overruled by subsequent Supreme Court decisions, that particular law or reasoning of the judge remains. And so we will have to bear with it. What the Chief Justice cannot do will be to bring a case on her own. If, for instance, the Chief Justice decides to go to court on a matter, then, of course, she cannot empanel. It is also a matter that involves her or a relative of her. She cannot also be a member of the panel. So those are the
but this matter, lawyer, clearly involves, it's about her. Would she not help if she then decides that, okay, on this matter, I should cede these responsibilities to the most senior most judge after me, so that I am not seen to be a judge in my own case? Because I can find at least some 5 justices that can speak for, make a decision that favors me.
I understand you. it is now up to her and her reputation. If she will decide to empanel, and then that panel also comes up with anything that goes in her favor, it will not let, in quotes, any victory scored by her to be genuine. I hope you understand what I'm saying.
Yes.
So it will be in her own interest to even say that, look here, since this particular matter involves me, I'm going to cede that responsibility to my immediate senior at the bench, and for that person to particular matter. Take note that even in the Constitution, the Chief Justice will be suspended by the President while this particular matter is under investigation. Now, if I were her, I would say, okay, these are the options that the President has in even suspending me. So why don't I ask the President and tell the President that, well, since this matter involves me, respectfully, I want to step aside and be finished with this matter. Depending on the outcome, then I can probably get back to my position. She could do that, and that will look noble. But this is what I think. That may be not the way she is thinking. And so we should not also fault her, because the system has not compelled her to as it were, step aside on her own volition. It is the Constitution who is saying a particular thing. You realize that this as a matter which is before the Supreme Court. Technically speaking, it has become moot, because what he was asking that the Chief Justice should be finished with, the Chief Justice has been giving all those things, and he has even gone to the extent of providing those initial responses or reactions to those allegations that have been made against her, right? And so, technically speaking, if the case should be called tomorrow, there will be nothing to deal with, because there will be no live situation for us to say this is what is happening, and so there's going to be an order from the Supreme Court, and that order will have to be complied. But the Supreme Court can still decide to proceed with the matter, and the reason will be that, look, this whole thing is taking various twists and turns, so we want to seize this opportunity and settle the matter and tell people how, in the event these cases involve the Chief Justice, how they should go about it. I hope you understand what I'm saying. Because even in the matter of what's the name? The earlier matter involving Bright Equities, in the J case, case, it was even suggested that because the Council of State may not be close with the expertise to probably make a determination as to the Prima facie matter, they will have to appoint a special person to deal with that matter. I disagree, and I disagree because, as I said earlier on, there is a member of the Council of State who is a former Chief Justice. So if it comes to the determination of the Prima facie case, that particular person can be an expert in that area and can deal with it. There will be no need to go and ask somebody to come and do this work for the Council of State when they have persons who have that skills, and which skill may be even over and above the supposed expert who is going to make a determination as to whether or not a Prima facie case has been established. But of course, what had been made clear in those cases, those two cases, is the fact that because the Chief Justice happens to be a justice of the Superior Court, whatever is done to justice of the Superior Court, she must also benefit the same, apart from the special nature of her matter, which would now this time be the situation where the President will appoint a 5-member panel, which will have to go into the
I see. And let me conclude on this. The Chief Justice currently, in fact, the processes are ongoing. There are many opinions being expressed. I'm sure if this thing is happening, if you are the one being taken through this process, you'll be listening actively to radio, people shouting she should go. let her step aside, among others. How should she conduct herself in the midst of all this? How should she conduct herself?
I will, if I had the opportunity of advising her, first to keep her, not to make any comments, not to be saying to agitate.
Hello, La. Hello. Hello, Council, can you hear me?
Yes, I can hear you.
Okay. We didn't hear what you said in response to that question.
Yes, so I said that if I were to advise the Chief Justice, I would tell her to stay focused. She should be.
And so, the line has gone bad, but I guess we can leave it there. Yeah. Thank you to lawyer Paul KUMI. The line just went bad. He's a private legal practitioner also speaking to us. So we've spoken to David Ametepe, Paul KUMI. What do you think? What's your own view on what has transpired thus far? First, let's establish this. There's no one that's beyond